Hi there, Paul Managrasso over at CFOAttorney.com, and today is Trial Tuesday. I thought today would discuss the Miranda warnings. I see it often in my practice where what we refer to as the citizen accused will come to me and they say, well, the police never read me my Miranda warnings. I said, okay, did they ask you any questions? Well, no. Okay, this isn't a problem. So what is a Miranda warning, and for that matter, who's Miranda? Now, in 1963, a fellow named Ernesto Miranda was arrested in Phoenix, Arizona for kidnapping and rape. After 2 hours of questioning, he confessed. No one told him that he had the right to remain silent or the right to an attorney. His confession was used at trial and he was convicted. The case reached the Supreme Court, and the question before the court: can the police use a confession obtained during custodial interrogation if the suspect wasn't told about their rights? Key phrase, custodial interrogation. If they're just talking to you at the side of the road, or it's just a meet and greet, you are not in custody. So there's no requirement to read you your rights because you have not been detained to the point necessary to invoke this privilege. So 5-4 decision, the court ruled that the Fifth Amendment protects people from being forced to incriminate themselves. Sixth Amendment guarantees the right to counsel. So they retried Miranda without the confession and found him guilty again. So years later, Miranda is out, and the way that Mr. Miranda was making his living was selling the Miranda cards that the police use. He was selling them for $1.50 in bars. Well, in 1976, he got into a bar fight with a guy and was stabbed to death. And when the police actually captured the suspect at the scene, he reached down onto the floor and there was this blood-covered Miranda card that he actually read the suspect his rights off of. So, truth being a little bit stranger than fiction. That's it for today. Have a great one, and we'll see you next time.